I don't know.
701 and 701.1, Mr. Venu, there is an AOR. I have received instructions from him. Firstly, he is indisposed, can't walk, being 87-year-old. And
what we'll do is in all these matters,
yes,
the idea is to get these matters ready for hearing.
Yes.
So we'll pass a common order in all these matters in terms of the circular of the 22nd of August 2023, that the compilation of documents, the compilation of pleadings, documents and precedent, that must be all filed within, say, we'll give 3 weeks to everyone, and written submissions as well. And we will appoint nodal counsel in every matter, who will then prepare the common compilation. What we suggest is, instead of us really making a roll call,
We'll give the names of the nodal counsel.
if everybody just gives the name for each matter, the name of the nodal counsel, so that their names will be included in the order. So that
My only request is if your lordships can tell us the dates, because unless we know, we have to prepare ourselves for this. That your lordships should tell us in advance, that's all.
Certainly. What I'll do is, I'll prepare the calendar. I'll just look at how the calendar is situated for all the benches.
Correct.
And probably do that by this evening or by tomorrow evening.
Fair enough, fair enough.
That I can just sort of space them out.
Yeah.
And if also on the same page, piece of paper, everybody can indicate, I mean, obviously these are not hard and fast, estimated time for the matters, because then I know how much gap to give before the next matter.
Fair enough, fair enough.
That may not be very accurate for the reason
Obviously,
that we don't have papers, we don't have the exact parameters of the matter.
Many of these matters have now been pending for 20 years.
Some of them can also finish in a day, some of them are very short matters also.
Yes.
Time limit is useful.
Yeah.
Well, there is one additional point as far as the tribunal matter is concerned, which is 705. What has happened is the referral order only refers to referring the money bill issue to 7 judges.
yes,
But
yes.
in para 118, the Honorable Supreme Court says the question as to whether all the tribunals should be shifted to an independent ministry has to be decided. This also should be referred to the larger bench of 7 judges. But in the concluding paragraph, that has not been added.
So we can, when we are formulating the questions, and when the matter is called out, we can always reformulate a question
Because
May I suggest, my lord, if it appeals to your lordships, but after, my lord, your lordships stipulated date for us to, my lord, keep our house in order, my lord, the numbering, etc. is done. If your lordships can keep the matters again for directions, some questions may have to be reframed. Your lordships may individually give dates. By that time, we'll be ready with the time schedule, my lord, which we will take.
Instead of doing that, because then after we give directions, again, they will go back,
They may
go back
delay
by
the
about
matter.
4 weeks. We'll give sufficient time here. So should we quickly call out each matter and just find out what each matter is, and then, not more than a minute for every matter. So
Fair enough.
just let's find. Let's go with 701.
701, I'm preparing for Mr. Venu Bhagat, who's for the appellant. He wrote a letter to the registry that he is unable to contact his clients whose firm is now defunct, and 2 of the partners have died. And the question involved, as he told me, was that whether there can be a sales tax on the sales tax for the goods sold, and is covered by a 6 judges bench of.
That has been referred to, sir.
Yes, that is why it was.
So we may still have to resolve the question, irrespective of whether, somebody is available or not. We may then appoint an amicus to assist the court on the issue.
I'm appearing for him in 2 appeals only.
And how many appeals are there in that batch?
Yes, I'll just.
There are 11.
Yes.
Who's appearing in the other matters in 701?
That question arose under
There are 9 matters in 701. In 701, there are 9 matters.
11 matters.
11 matters. I stand corrected. Maybe something is added.
No, not.
What about the other appeals? Is there somebody appearing in the other appeals in 701?
Yes, my lord. 701.
I am appearing in 7012, my lord, which is a matter of the state of Punjab.
For the petitioners?
That's
I'm appearing for the respondent, ma'am. 701.2.
And for the private parties, anybody else who's appearing? We'll list the matter sometime. So what we can do is maybe 701, we can list for directions immediately and then see if that really survives. If it doesn't survive, then we'll close it because now this is a legacy issue.
Very well.
All right. What about so we'll, 701 jo hai na, just keep it for direction so we can spend 10 minutes and see if that matter survives from Punjab.
Lordship, please, sir.
The privilege is of the assembly, my lord, Tamil Nadu assembly. My lord.
That's,
I
that's,
think the
I
union
in
has
that
to be-
matter, that's the,
All the states.
All right, so there we will
that's
give
the power
directions.
of the speaker to arrest, that's the issue.
Right. We'll give directions then, the usual directions in that matter.
Only one request, please.
Your Lordship issued notice to the Attorney General to assist the court in this matter. So that's why I'm here.
But, my lord, in few matters, though union has something to say, we are not parties. If your lordships can pass a general order, implementing union as a party, we'll waive. We don't wish to delay the serving, etc.
But you can, anyway, we can assist the
But
courts
it's
in
in the
independent of that. We'll
704.
permit.
Formal that may be necessary, my lord, for us to file pleadings, etc.
In the entirety of.
No, there are 2 or 3 matters where we are.
The speaker has nothing to do with the union.
But if we require some assistance from the
Okay,
attorney.
here I have no problem, but otherwise, Madam, it's an issue.
Anyway,
between
notice
the
has been
speaker.
issued to the attorney general.
That's-
We will say that on the, we'll permit the union
No
to be.
problem, I don't say that, but
Let them be there. We'll have some more assistance
No problem.
on this side as well.
no problem.
I appear for the,
To amend the,
in 702, I appear.
to impede the Union of India. Mr. Tushar Mehta, Learned Solicitor General, appearing with that no further notice
Will
is
do.
required. On 701, 702. Just make sure that all the names are, yes, they will clarify that.
That I appear for the speaker of the legislature.
All right, so we'll give directions for listing 702. We have a few CBs which are already listed immediately, and immediately after that, we will take up.
Fair enough, fair enough.
All right.
703. Lord, as far as this is concerned, this is the Aligarh Muslim University matter.
Minority status.
Now, there are two directions your lordship would have to pass. The first is in the High Court, notice was given to the Attorney General. So that may be done in this case as well.
Like notice to Attorney General.
The second is a little more complicated. The union supported the minority status both before the single judge bench and division bench. They filed an appeal against the division bench order which said that they are not a minority. They have now filed an affidavit in 2016 saying that they want to withdraw their appeal. Now their status would have to be determined whether they would be respondents.
That
because
is
they
when
would-
it is called out, my lord. That's a contentious issue.
Apart from the appeal by the union, who else has filed an appeal? There's other appeals as well.
The university itself.
There are 8 appeals, 5 by AMU, that's the university, and 2 by private parties. But this issue has to be decided,
This will have to be
This will
decided.
have to be decided, yes.
and it can be decided as a preliminary
No,
issue.
we'll have to decide the issue.
Yes.
When the matter is called out, we'll see what the
That's
impact is.
And notice to the Attorney General.
With that, we've already issued.
I'm already here.
Lord, what I've done in this is I framed 5 issues which can be uploaded to your lordships. Can we just put that?
If you can share it with us, we can.
Dr. Dhawan, if you could share it with the Attorney General, so that, then they can respond to you, and when the matter is called out, we can, before we begin the hearing, we can finalize
You've
it.
already uploaded it, Vinod.
So kindly serve a copy on this. That's the request.
Absolutely, we'll argue it.
Very well. 704.
704, I appear for the state of Punjab. Because here the issue is that subclassification within the scheduled caste, the state had
Chinaya.
passed.
Chinaya.
That's right. So Chinaya has to be relooked at. Because the Learned Advocate General of the state is also appearing online. So Malaz may appoint Malaz from our side, Mr. Karan Sharma as the nodal counsel.
So, as I said, in all matters,
We'll give the
please
names.
give the two nodal counsels.
My lord, instead of troubling your lordships.
This matter will require hearing, my lord, because we have a category of Valmikis within the scheduled caste, my lord, which was under challenge and the High Court has squashed it. So we are in appeal.
What we can do is that we are circulating soft copies of everything now. So your note, your written submissions, etc., can be formed in a compilation, and the two nodal counsel will put everything together for every matter.
Right.
Not necessary right now because it will just get lost in the papers. So it will be much better that you give it to the nodal counsel so that they are uploaded, and then we have everything down in one compilation.
In fact,
Yes.
in 704, I had appeared before the 5 judges bench for a private.
This, that
I
money
think
bill issue.
It's a matter of importance where the union may have to be heard.
No, this is the money.
Union may be implicated.
704 is going on.
704.
Yes.
Union may be implicated. We'll waive that.
And 705 is the money bill.
705 is the reference in Roger Matthew.
Yes, now that's something that should be decided, Malaj, that's my request. Malaj, give it priority because that's a really live issue, Malaj.
All right,
That's my request. It cuts across, Malaj. But there are several.
We'll give that some priority, Mr.
The priority is your lordship's discretion. We would request your lordships may go, my lord, seniority. It's entirely my lord's discretion. We cannot have it. We can't decide priority.
We can't argue on this, Malaj.
All right, we'll leave it to us. We'll take up that.
I appear for the respondent, my lord, 705.
We can't decide priority based on political exigencies. That's all.
That your lordship will decide, not which.
Please decide, Malaj. I think there is some.
There's also an amendment by the.
706 is Subhash Desai, Malaj, that issue.
Where we referred it recently.
That only requires half a day, Malaj. That's not a matter that will last very long.
Not very long.
Yes.
That's the review of the legal of Nabam Rebia.
That's correct.
Yes.
Nabam Rebia did.
So
Are you going to really press that issue, the reference of Nabam?
they should accept what we are saying, Malaj. This is not a matter, Malaj, that
We'll see whether.
yeah, that's clear, Malaj. That's the whole issue is very clear. It'll take only half a day, Malaj. That's it. Very clear.
901.
Excuse me.
Please, ma'am. 901, my lord, there are two sets of matters, one relating to MADA challenge to Chapter 8A, and one relating to the Maharashtra Rent Control Act.
Right.
So there are a series of orders which 3 judges referred it to 5. Then
5 to 7 and 7 to 9.
my lord.
But now that has to be resolved one way or the other.
That's it.
Yep.
Interesting questions on interpretation of Article 31C, 39B.
Yes, Mr. Attorney.
There I left to appear for Mada and the.
I am for the state of Maharashtra.
Just the court appeal. Yes. 902. So we'll again pass the same order. Please, before leaving, give us a list of nodal counsel because the whole purpose of this hearing is to get the matters ready for hearing in the next 4 weeks or something.
Well, in 901, I have circulated a note giving a background of those 3 orders, which were 3 to 5 to 7 to 9.
All right.
And because the reference has not been made specifically to any issue. Well, let's kindly look into that note so that it can be taken. Great.
In 902,
902, I'm appealing for the petitioner.
11 issues, my lord.
Appellants.
What is the issue?
It's about the
India
land
Cements.
tax that was imposed on mining land, mineral land.
Under state tax on royalty.
So it was cut down based on India Cement.
India
was
Cement,
saying
yes.
as royalty is tax and therefore. And then Kesharam came subsequently where I also appeared, Lord, and then they distinguished that. Then subsequently in our case, Lord, Justice Kapadia, Chief Justice Kapadia, Lord, he said, Lord, that there is a conflict between 7 and 5 and therefore.
Therefore, it's gone to 9.
Well, Lord, one other thing in 902, apart from the 11 questions, what is actually the burning problem now? If your lordship holds that mining royalty is a tax, then the additional consequent question is whether you can levy service tax and GST on that tax. That is pending in Jodhpur, Madras, Assam. Against all the petroleum companies, we are paying royalty. And on that, they are demanding GST and service. Amounts have become very large now. So at the early,
But this has to be resolved early. It's been pending for almost 20 years.
24 years.
Yes, the area is mounting, my lord, that's the problem.
And it's not good for anybody ultimately that these tax users.
Milord,
There will be a problem in payment also,
May I say one more?
goes in our favor.
Milord, subsequent amendments in MMDR.
because that what happens on royalty, we pay GST service tax, and that is not be able to set off to the consumer. So it's a cost to the oil companies.
All right, we'll list this. We will certainly give this priority in the 9 judges because it's in a 9-judge complex.
Yes, 9 judges.
Pending since very long, Milord, 2011.
So this is a question relating to industry.
Yeah, section 2J of the Industrial
Area of
Disputes
the
Act.
industry. Now, the referral order is not very clear to us with respect. Now, the issue there in Bangalore water supply was with reference to municipal corporation. But the court has undertaken the task of examining whether education is an industry, sovereign functions.
Clubs, whether clubs are industry, sovereign functions, Panjra polls.
Bangalore water supply.
Bangalore water supply, 78 Supreme
So
Court.
the Cricket Club of India, all those judgments were reviewed, which in my respectful submission were not within the scope of Bangalore water supply on the facts of that case. But since now it is referred to larger bench, whether we are permitted to address the court on all issues or whether with reference to the sovereign functions of the state, because in
The Department of Narcotics is held to be an industry. So it,
I am concerned with Forest Department for the state of Maharashtra.
And Forest Department also, there are a large number of cases across India. Irrigation Department, Forest Department.
State of UP also.
Even university. Then we get into Bangalore water supply.
Of course, Bangalore water supply now has stood the test of time for almost 45
It takes
years.
some time.
So
Because if the entire judgment is to be revisited, then it will take some
we
time.
take a call once the matter opens as to whether, it's desirable that a judgment which has held the field for 45 years should at all be reviewed. Or what is the great public injury that has happened now as a result of that?
Lordship can fix it between the Dussehra holiday and Diwali holiday, in between that.
We'll
In which case, I think union may have to be heard on the
Yes.
the industry. Yes.
So we'll issue notice to the attorney. And here also impede the Union of India.
Milord, in fact, it's been amended. So there is no need for this matter to go to a larger bench, Milord. That would be my submission.
Yes, that you can argue when the matter is called out.
May I mention the matter, Milord, of 2006, which was where I've been referred to be taken up along with this, the main matter, Milord. My matter is not listed. So may I request that this...
Has that been tagged with the 9 judges bench matter?
Well, it's supposed to be taken up after the judgment of the 9 judges bench. Milord, this 2006 matter, I'll address your lordship.
Give a small note to the registrar listing who is in the court. And I'll take a call on whether this has to be placed with the 9-judge bench. Just give it to the registrar.
Very well.
By the evening, give it to him. I'll take a
Yes,
call.
by this.
Issue administrative.
Yes, much.
Yes, Lord, we are appearing to the state, Lord, in this matter, Lord. Then the issue is with regard to the state's jurisdiction to regulate industrial alcohol.
Synthetics.
Oh, synthetics and chemicals. Justice Sabyasachi Mukherjee, Judge.
I'm appearing for the
Lord, there is one, we all appearing. Lordship, we have to make the union as a party because it's British.
I think union, I have to be heard.
Yeah, we'll shoot the
Yes.
union. And waiting.
They're not formal parties.
Yes.
There was one more request, Lord, if Lordship's deem it necessary. Because.
Cannot wait.
Wonderful.
Union and the state with regard to regulatory power over industrial alcohol. And it's an important matter because for the states, it's an important matter. Their power to regulate has been taken away by synthetics. Now, Lord, in the synthetics itself, the Supreme Court considered all the states, all the states participated and argued the matter vis-a-vis the power of the union and the state. So what we submit with respect, subject to what Lordship decide, would it be appropriate for Lordships to call all the states over, notify them?
What do you say, Mr. Attorney? Notice to all the states in this?
Or it can be verified.
Yeah, all the states.
They are to.
Can it be on a website?
Say that liberty to, notice shall issue to all the state governments and the governments of the UTs as the case may be. Liberty to serve the standing council. Notice shall be served in the standing council for the respective states stroke UTs.
My lords, they are.
My lord, the notice to the Attorney General has already been sent, has been given.
But they have not been tagged. So we can provide with the list of those appeals which are pending, which may be tagged with this.
We can do that, or we'll hear the states here and this judgment will follow and.
The SSPs have to be also heard in them.
All right.
My only reason was not since in the
No,
earlier.
if you're right,
all was
really we have to hear the states. States are vitally concerned.
Right.
It's really essentially a turf, constitutional turf between the union and the states.
Yes.
Because the law is, potable alcohol is in the jurisdiction of the states, industrial alcohol, the center. But the states can pass legislation or regulations to ensure that there is no diversion of potable to industrial, or industrial alcohol to potable.
That's
Denatured.
the problem. The problem is otherwise. If Lordship could see till 1990, states were regulating industrial alcohol as if it was a privilege. It was 1990, this theory was not exploded and the state's power was taken away by the center because IDR Act came in.
My lord, in fact, subsequently in 2005, the IDR Act has been amended and potable alcohol has been excluded from IDR. It's only the industrial alcohol.
The issue is, can you do it in IDR or the state's exclusive jurisdiction? How can you take it in IDR?
Right, we'll have to see.
Lord, before your lordship takes that matter, Lord, there is one confusion, if your lordships can grant indulgence. All of us are making this request. My lords have fixed one 7-judge bench matter, my lord, on 5-judge bench on 17th. Well, that is that Assam section 6A validity matter, my lords. But yesterday, my lord, we were informed that the entire week is a miscellaneous week. All of us are appearing, my lord.
That will now go to the 7th of November.
Please.
7th of
That's
November.
all we, my lord.
7th of November.
Milords, may I make one small request, Milords? Milords, I'm here, Milords. Milords, in 703, Milords, would the registry be able to provide us with all the pleadings in the pen drive form, Milords, because that becomes easier. These are very
all matters, my lord,
The courtmaster just told me that he's adding that as one sentence in all orders. The
all
registry
matters.
will provide soft copies to all the
Lords,
councillors.
in that regard only, Lords, I have to just make a submission, Lords. I had the occasion to go through some of the scanned records last night after the list was uploaded. There are certain, Lords, it is very convenient for us to actually download it from the e-filing to portal. But some of the scanned digitalized files have a watermark of draft or something else written in the entire paper.
That watermark will go now. In fact, that was pointed out to me last night by the registrar IT. He said, sir, there's a problem. We have scanned this file. Some of them have watermarks. They're dealing with it. Don't worry. In fact, it was brought to my notice last night before I was
In 902, Lords, I have one more additional submission to make. Lords, there are 6 transfer petitions in the batch. Lords, the batch has grown from 41 to 84 matters in 902. And Lords, 6 transfer petitions, 6 SLPs, then 4 writ petitions and 68 civil appeals. So well, it's transfer petitions, the main substantive challenge is pending somewhere else. In that regard, Lordship may have to take a call whether
to allow the transfer petition and bring those matters.
yes, that should not delay the
Yes,
hearing.
can you do one thing? If you can give the court master the list of the transfer petitions.
Yes, I have.
I'll list them for directions independently on some day. So that then everybody in those transfer petitions will be here and we'll take a call on what to do in those.
What can be done, either not to separate them and.
They are with the judge.
Allowed to intervene only, that.
Instead of bringing everybody here. That may
Otherwise,
be altogether better.
Just to intervene if they.
Somebody may seek
If
time
somebody
to
wants
file
to
reply,
intervene, they can
etc.
argue the question of law, assist us in the question of law. Fair enough. I think that's better.
Grateful to.
Please, Your Lordship. No, correct. Thanks. Yeah. Yeah. Lord, just to summarize, my Lord, there are 3 broad reasons why Your Lordship should be pleased to leave the issue of determination of stamp objections to the tribunal. The first is the doctrine of separability, which is housed in section 7.2 and 7.5 of the Arbitration Act, as well as, of course, most prominently in section 16. And the question whether, even if the main contract is null and void, whether an arbitration agreement survives, to consider that very question is directly covered by 16.1b expressly. 16.1a is separate, the arbitration clause is separate, and 16.1b directly covers the issue. Now, very briefly, therefore, whether the first argument is whether or not it is invalid, it goes to even existence, or whether it is only an irregularity and a curable defect. I'll come to that later, but assuming it is the worst, it's an invalidity. Even then, my submission is, by virtue of the doctrine of separability and competence, which our Act fully now recognizes, these are issues that must be left to the arbitral tribunal. And I'm going to save the court's time. I'm not going to take my lords through each of the judgments, but I've summarized from my revised submissions are now found in volume 1B, page 2. And from page 7 onwards of volume 1B, I've just extracted some of the major decisions, internationally as well as ours, on separability. And to which, of course, I'm going to add one when I show it before my lords. Page 7 of volume 1B. It's been added last night. Been uploaded now. My earlier submissions were in volume 1, but since we made a change, there's one mistake which we corrected.
Over here, it's updated submissions.
Updated submissions. I'm updated.
There are 38 pages.
38 pages. But that's because I've extracted judgments there, so it's easier for me to read from there rather than troubling my lord to go to the actual judgment. I'll be going to the actual judgments in only 2 cases, which are quite critical.
Is it Harbor Assurance Company?
Yes, it starts with that.
That's the Queen's Bench decision.
That's right.
Oh.
It starts with that Court of Appeals.
Yes.
Yes. If my lords just see para 9 onwards, Harbor Assurance arbitration agreement is a self-contained agreement. In Involnat, it was held that it's a self-contained agreement which is separable from the main contract, therefore has autonomous existence. In our own Enacon, expressly under section 16, your lordships have held that section 16 accepts the concept that the main contract and the arbitration agreement form 2 independent contracts. And then in para 83 again, the Supreme Court calls the arbitration agreement a second contract. Redfern and Funto also speak of 2 separate agreements, primary or main contract and a secondary contract. Then if we go straight to para 14, Gary Bond, the arbitration agreement may exist and be substantively valid, notwithstanding the non-existence, invalidity or illegality of the underlying contract, and the arbitral tribunal may and must consider challenges to the existence, validity or legality of the underlying contract because such challenges do not impeach the arbitration agreement. Then Fiona Trust. Arbitration agreement must be treated as a distinct agreement and can be void or voidable only on grounds which relate directly to the arbitration agreement. These are all very well settled principles, so I'm not troubling I'll just quickly go through this. Now, next page, again, the validity of the arbitration agreement is not undermined as a distinct agreement. The US Supreme Court has also taken the same line in Buckeye check cashing, which your lordships have followed. That despite the invalidity of the underlying agreement as a whole, arbitration agreement will continue to be enforceable apart from remainder of the contract. Para 17, page 11. In Ayaswamy, your lordships have held that the adjudicatory power of a tribunal remains unaffected by any objection to the main contract. And in Vidya Drolia, which I have not mentioned here, but which I noticed, my lord, during the hearing, which I'll be showing, again, paras 173, 174, expressly say arbitration agreement is a separate contract in itself. The Singapore position, which I've set out from paras 19 to 22, 23, really says the idea is to insulate the arbitration agreement, even though it may be integrated into a main contract, from objections as to invalidity of the main contract. So the law of separability is very, very well entrenched in our law. And my lords will notice that both in Ayaswamy and in Vidya Drolia, separability is spoken of as a concept which actually permeates the Arbitration Act. It goes beyond just matters where there is a challenge under section 16 to a decision of an arbitral tribunal. So although the legal fiction, if I may call it that, in 16 is for the purpose of giving the arbitral tribunal jurisdiction to decide its own jurisdiction, it is not restricted to that. It's a wider principle recognized under our law and under section 7.2 and 7.5 independently of 16. Now, the only reason I say that is that with this, squarely, any such issues, whether we call them existential issues, whether we call them only irregularities or curable defects, must, in the first instance, go to the tribunal. And your lordships are always there at the stage of the award or the order, whether under 37 or 34, to have a look at how the tribunal has exercised its jurisdiction. I have also set out at page 14 of my submission, section 5 of the Indian Stamp Act. This is really a matter ultimately that the tribunal will go into, but just for completeness. Section 5 of the Indian Stamp Act recognizes a position that a single instrument may pertain to several distinct matters. And in which case, according to the Stamp Act,
This is the second point you're making.
it's really part of this separability point. If it pertains to distinct matters, the aggregate of the stamp duties on each of those distinct matters must be worked out. Now, if an arbitration agreement is separable, then perhaps a tribunal may be persuaded to hold that there must be separate stamp duty and all. In other words, separately on the arbitration agreement, which is what your lordships have held in NN Global under the residuary clause, as well as substantively on the value of the main agreement. This, of course, is a matter for the tribunal. I'm not suggesting my lords should decide this. My lords have made it clear your lordships are not deciding chargeability. But I'm only placing it before my lords because this is how the issue will come to be decided. And at para 29 of my submissions, I've referred to your lordship's judgment in Chief Controlling Revenue Authority, which affirms a passage from Halsbury in relation to Section 5 of the Indian Stamp Act, that an instrument containing or relating to several distinct matters is to be separately charged as if it were a separate instrument. So even under the Stamp Act, there is some concept of separability. Now, it may be that a tribunal takes the view that no, stamp is payable only on the whole. Or it may be that it takes the view that it's payable separately under each. That's a matter of chargeability. But that decision, in my respectful submission, must be by the tribunal.
Forum is the only issue. It's the forum which is an issue.
That's
What
it. This is
will
the forum.
happen, will it happen, not happen?
Precisely. Precisely.
The whole purpose is to shift the forum to the arbitrator so that arbitration proceedings don't get delayed at the threshold.
I
You
couldn't
go
have put it.
there and then you argue it out if something is the consequence that is there. But the court under 11.6 is the only issue really which we are touching.
That's it. Now, my lord, for that purpose, I want to show my lords two judgments, which my lords have seen, but I just want to emphasize certain different aspects of them. The first is my lord's decision in the Ayasami case, which my lords will find in volume 5A at page 1336. There are three important principles laid down here, which I want to just, press into service.
3,000?
1336, page 1000 of volume 5A. This is 2016, 10 SCC 386. If my lords would kindly turn to page 1359, para 33. Para 33 says, Section 16 empowers the arbitral tribunal to rule upon its own jurisdiction, including ruling on any objection with respect to the existence or validity of an arbitration agreement. Very important because existence, even assuming stamp goes to existence, it's housed with the arbitral tribunal under 16. 16(1)(b) stipulates that a decision by the arbitral tribunal that a contract is null and void shall not entail ipso. Yes. 16(1)(b) stipulates that a decision by the arbitral tribunal that a contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. Hence, the invalidity of the contract between the parties does not render the arbitration agreement invalid as a consequence of law. This recognizes as inhering in the arbitrator the jurisdiction to consider whether the main contract, other than the arbitration clause, is null and void. The arbitration agreement survives for determining whether the contract in which the arbitration clause is embodied is null and void, which would include voidability on ground of fraud, The severability of the arbitration agreement is a doctrinal development of crucial significance, for it leaves the adjudicatory power of the arbitral tribunal unaffected over any objection that the main contract between the parties is affected by fraud or undue influence. My learned friends, for the respondents in their submissions, have argued long and hard that the doctrine of separability should not be applied to a stamp issue. If that is so, even then, by virtue of section 16, that issue must go to the arbitral tribunal. The next para is para 46 at page 1366. I'll just read a small portion of it. At page 136, at para 46, my lords have cited Fiona Trust. And then at the bottom, placitum G. Arbitration must provide a one-stop forum for resolution of disputes. The Court of Appeal held that if arbitrators can decide whether a contract is void for initial illegality, there is no reason why they should not decide whether a contract is procured by bribery, just as much as they can decide whether a contract has been vitiated by misrepresentation or non-disclosure. So the second principle is also accepted in the Vidya Dhrolia judgment of a one-stop forum for adjudication. Deciding a stamp objection in court before making a reference will violate this principle as well. And your lordships have given the reason underlying para 46 in para 48, which is 1367. The basic principle which must guide judicial decision making is that arbitration is essentially a voluntary assumption of an obligation by contracting parties to resolve their disputes through a private tribunal. The intent of the parties is expressed in the terms of their agreement. Where commercial entities and persons of business enter into such dealings, they do so with a knowledge of the efficacy of the arbitral process. The commercial understanding is reflected in the terms of the agreement between the parties. The duty of the court is to impart to that commercial understanding a sense of business efficacy. So the second one-stop business efficacy, parties intended that one forum would decide all their disputes and it would not be split amongst different forums. And the third principle, a more general principle in para 53, 1369. The Arbitration Act should, in my view, be interpreted so as to bring in line the principles underlying its interpretation in a manner that is consistent with prevailing approaches in the common law world. Jurisprudence in India must evolve towards strengthening the institutional efficacy of arbitration. Deference to a forum chosen by the parties as a complete remedy for resolving all their claims is but part of that evolution. Minimizing the intervention of courts is again a recognition of the same principle. And the principle, of course, as we have seen, is housed in Section 5 of the Arbitration Act, which has a very far-reaching non-obstante any other law. So that is Parliament's legislative intent reflected in Section 5. Therefore, these are three principles. Now, these three principles and two more have also been categorically affirmed in the Vidya Dhrolia decision of your lordships, which is to be found in volume 5, page 76. The 5 principles that I rely on Vidya Dhrolia for. First is separability. Second is full competence, that is both positive and negative. Third is the prima facie test. Fourth is that even under 11.6a, only the contractual validity of the arbitration agreement is to be seen. In other words, coupled with the prima facie test, if the court is prima facie satisfied that there is an arbitration agreement within the meaning of the Arbitration Act, then that is all. Nothing more has to be seen under 11.6a. And the fifth is these principles of a broad pro-arbitration interpretation to respect party autonomy, and one-stop adjudication, presumption of that. These are the 5 principles that have been laid down in Vidya Dhrolya. And may I quickly run through the paragraphs? Both the learned judges have decided this. The judgment is found at page 76, 2021, 2 SEC page 1. First, para 126, if my lords would kindly go to.
Which volume is this? 26, is it?
At page 182. 5A, 182 is para 126. First is separability. I'll just show both the judgments are ad idem on this. Para 126. Page 182 of volume 5. My lords have it. Yeah. Para 126 covers both separability and competence. We would now examine principles of separability and competence. Clauses A and B to subsection 1 of section 16 enacts the principle of separation of the arbitration agreement from the underlying or container contract. Clause A, by legal fiction, gives an independent status to an arbitration clause as if it is a standalone agreement, even when it is only a clause and an integral part of the underlying or container contract. Clause B formulates a legal rule that a decision by the arbitral tribunal holding that the main contract is null and void shall not ipso jure entail invalidity of the arbitration clause. Successful challenge to the existence or invalidity or rescission of the main contract does not necessarily embrace an identical finding as to the arbitration agreement, provided the court is satisfied that the arbitration clause had been agreed upon. The arbitration agreement can be avoided only on the ground which relates directly to the arbitration agreement. Notwithstanding the challenge to the underlying or container contract, the arbitration clause in the underlying or container contract survives for determining the disputes. The principle prevents bootstrapping, as it is primarily for the arbitral tribunal and not for the court to decide issues of existence, validity, and rescission of the underlying contract. Principle of separation authorizes an arbitral tribunal to rule and decide on the existence, validity, or rescission of the underlying contract without an earlier adjudication of the questions by the referral court. Para 173 and 174 are the equivalent findings on separability in the second judgment, page 200 of volume 5A. Arbitration is a creature of consensus. It is completely dependent on party autonomy and the intention expressed in the agreement. A contract having multiple clauses, including arbitration agreement, can be divided into 2 parts. The clauses relating to the commercial relationship, i.e. obligations and duties of each party, can be referred to as the main contract. The arbitration agreement, so to say, is a separate contract in itself. And then His Lordship finds that separability of the arbitration agreement from the main contract historically existed even in Roman law and later, of course, in German and Swiss jurisprudence. Now, competence. Again, para 126, I've shown my lords. Para 129, if my lords will also kindly see, is also very instructive. At page 183. Principles of competence have positive and negative connotations. As a positive implication, the arbitral tribunals are declared competent and authorized by law to rule as to their jurisdiction and decide non-arbitrability questions. In case of express negative effect, the statute should govern and should be followed. Implied negative effect curtails and constrains interference by the court at the referral stage by necessary implication in order to allow the arbitral tribunal to rule as to their jurisdiction and decide non-arbitrability questions. As per the negative effect, courts at the referral stage are not to decide on merit except when permitted by the legislation, either expressly or by necessary implication, such questions of non-arbitrability. Such prioritization of the arbitral tribunal over the courts can be partial and limited when the legislation provides for some or restricted scrutiny at the first look referral stage. Now, this is a judgment, I believe it's the first, which divides up even negative competence into express and implied, and that is correct. Because very often a section will not actually say a court should not interfere. But an interpretation of that section, given Section 5 of the Arbitration Act, leads to an implied negative competence or a stepping back, as it were, of your lordships at the first stage. Because the whole scheme of the Act, the architecture of the Arbitration Act, is geared not towards front-loading, inclusion by a court at the beginning, but towards a scrutiny after an award is passed. So it's not the arbitration that is heavily supervised, it's the award that is looked at when it is challenged, or of course an order under 37, if there's an appeal. And the same thought permeates through paras 178 and 208. I won't read them. The equivalent paragraphs, I won't read them, are para 178 and 208 in Justice Ramana's judgment.
178 and 208.
178 and 208. The third principle, and this I want to place, because this is the prima facie test. We have heard a lot about Section 8 is only a prima facie approach. What is a prima facie approach? How does a court apply it? Para 147.11, page 194, tells us how to do that. The second sentence, the court as the judicial forum of the first instance can exercise prima facie test jurisdiction to screen and knock down ex facie meritless, frivolous and dishonest litigation. Limited jurisdiction of the courts ensures expeditious, alacritous and efficient disposal when required at the referral stage. So something which is ex facie meritless or frivolous. Ex facie, there is no arbitration agreement. That is something alone that a court will see under 11.6a. The rest, if there's even a dispute or a doubt, will be sent to the tribunal. When in doubt, refer, is what this judgment itself says. And a similar principle, I'll just mention the para number. At para 154.4, at page 196.
That's what we have said, even in the case of limitation, if you get a case under 11 where somebody's come after 10 years, 20 years, or something doesn't turn really on a very detailed interpretation.
On a demurrer.
Demurrer. Justice, I think, Justice Natsima and Justice Pardiola were sitting with me when we found a case like that. And then the whole object of sending parties to arbitration again it defeats the purpose of arbitration.
So without much inquiry, without determining some heated controversy between the two parties, if a court can ex facie see it, of course, that is a safeguard under 11.6a. No one is disputing that. But stamp will never be such a question, particularly because, as we have seen, it's a curable defect.
Bhavata, that's the whole thing, this Stamp Act. Anything to do with stamp. If it has a possibility of being curable,
yes.
Let us say even recognize the possibility of being curable, then how do you throw it out at a threshold?
I bow to that. My lord is absolutely correct.
So, in any scenario, possibly, Stamp Act requirement in any formulation of it, any variation of it, I'm very doubtful that at all it can be looked into.
My lord is right.
11.6.
I'm going to place a judgment of your lordships on that immediately after I complete this, showing that it doesn't, irregularity in stamp or even non-stamping doesn't render a document invalid. Your lordships have held that. I'll place that. But very quickly, I'll just give the paras on this. I won't trouble my lord. But the equivalent para is para 232, Justice Ramanna's decision, where he expressly refers to section 8. That is at page 234. And he says in para 233 at page 235 that the defendant has to establish prima facie case of non-existence. It's the other way around. The defendant will show that ex facie there is no arbitration agreement. Well, the fourth proposition, again, in the interest of time, I'll just give the paras. Paras 236 to 238 at pages 235, 236, relying on your lordship's Mayavati decision. Ultimately says it's only contractual validity of the arbitration agreement that has to be seen under 11. In other words, section 7, is it complied with? On the face of it, ex facie. If there's again, even on that, if there's a dispute to be gone into, it will go to the tribunal. But if ex facie, your lordship is fine. There's just no agreement, of course. And para 244.5 and para 146. They all go on the basis of this kind of validity. And my lord, I adopt Mr. Datar's submissions. I'm not going to repeat them under the Contract Act. What is not a valid contract or what is a void contract is only one which is voided under section 23 or under section 10. Nothing more than that. Stamp Act doesn't come into that at all, not even into the Contract Act.
We have elaborately at this moment.
Yeah, so I'm not touching that. I adopt that, my lord. And the fifth, my lord, set of paras in this judgment, I'll just give the para numbers. Paras 151 to 152, page 195. And para 220 at page 230 is again the principles of a broad pro-arbitration interpretation and a one-stop forum for adjudication.
What is the latter para?
Para 151, 152.
195.
At page 195 and para 220 at page 230. They speak of a one-stop adjudication presumption. You start from the presumption that everything goes to the tribunal. Now, applying this to 11.6a, It's not that because the word existence is used, everything coming under that umbrella of existence has to be gone into. The legislature has said confined to the existence, and given the principles under Section 5 and these very salutary principles of law, a court would restrict by way of an implied negative competence, even under 11.6a, to an ex facie examination. Now, my lord, this is more so because of the next point, which has been argued. I'll just point out what I think is relevant and which has not been shown to your lordships. Under the Stamp Act, 1, non-stamping or understamping does not result in an invalidity or voidness. And 2, it is a curable defect. Now, if my lords kindly turn to my written submissions, volume 1B at page 15. I won't read all of them.
It's also waivable. You can waive it because.
And one can waive it. My lord is right. In fact, there are 3-4 sections which I want to just point out. Again, I won't read them. They've been read. Barring one, they've been read to my lord.
Waiver is also by conduct. It's far more liberal. It doesn't have.
My lord is absolutely correct. And if that is so, then under 11.6a, how will a court go into that? I'm obliged. I'm obliged. May I, my lord, adopt that as my submission? I think that's very well put. In fact, as Mr. Banerjee also argued, an 11 court is not even a 2-1e court. Whether it can take evidence is also a question. But therefore, it's impossible to go into these disputed questions under 11.6a, despite the use of the word existence. That has to be read purposively as meaning only ex facie if there's non-existence. There's a probability of existence, it must go to the tribunal. Now, curable defect and invalidity. The first point. Section 35 is very clear. It visits a non-stamped or not duly stamped instrument with only 2 consequences. One is it is inadmissible in evidence. And the second is it shall not be acted upon. And my learned friends have emphasized the second, not be acted upon. And they have tried to elevate those words to unenforceability leading to voidness and invalidity. I'll presently show why that can never be so. The curable, where the defect can be cured is section 36 we have seen, where once an instrument is already admitted in evidence, no stamp objection can be taken to its admissibility later. Section 37 and sections 42, which I don't believe have been shown, 42 I don't think has been shown to my lords. But 42 only allows the collector on payment of duty and penalty to stamp the document, and after stamping, then it can be admitted in evidence, and the shadow, as it were, of section 35 is lifted. In NN Global 2, and Mr. Datar has pointed this out, there's a slight contradiction because in para 108, it is said this invalidity is not in the sense of being stillborn, but in para 103, it says it's bereft of life. We leave that aside because, in fact, your lordships have held very clearly that no invalidity results. I'll come to that just a little later. I will make 2 points before I come to that. My lords have seen Hindustan Steel. I'm sorry. The judgment in Hindustan Steel. And my lord, I've said this all out in my written submissions, pages, paras 32 to 47. So I'm not going to read it all. I'm running through this because much of this has been argued. I've set out with extracts from the judgments as well. Paras 32 to 47, starting at page 15. But I want to make 1 point. Hindustan Steel we have seen, and it is directly on point. about curability. But there's another aspect your lordships may take into account. There's a judgment of your lordships in a totally different context under FEMA, in the Vijay Karya case, which my lords will find in volume 5A, page 1545. I'm not even asking my lords to go to that. But the principle in Vijay Karya's case is this. I've referred to it at para 37 of my written submissions, and the judgment is found at volume 5A, page 1545. Citation is 2020 11 SEC, page 1. The relevant page number? The page number is 1545, volume 5A. And at 1632 is para 88, where your lordships have laid down a principle as to what happens when something is capable of regularization or post facto permission in the context of FEMA. This was that whole series of foreign awards coming. It's a general problem.
A very small niche point, which is that looking to the nature of Stamp Act.
Correct.
Are we required to look into Stamp Act at all under 11.6? So it should be left. This is all.
Yes.
Why should we go here and there on the issue?
Only to assist that conclusion that if it's a regularizable, curable defect, then your lordships, even in the context of other statutes such as FEMA, which also have a public policy connotation, have said the transaction is not voided. That's what para 88 says. The transaction is not voided because it's regularized. That's the only principle I want to cull out from Vijay Karya, but I'm not taking my note. I've set out, my lord, I'll just give my lords the reference in my submissions to the Singapore position on stamp expressly, my lord. My lord sees paragraph 80 of my submissions. Para 85 onwards, my lord, page 33. They have similar provisions. It's not that they don't. My lord sees para 86. (51)(1) of the Singapore Stamp Duties Act corresponds to our section 33, the impounding section. And section 52 in the next para corresponds to section 35. Same language. Not admissible in evidence, must not be acted upon. Identical language. And in para 88, I have referred to one decision of the Singapore courts, where it is categorically held that this is only a rule of evidence and does not affect the validity of an unstamped document. That is in this Muhammad Amin bin Muhammad type case. The case, I'll just state for the transcript, is found in volume 5B, page 4678. Even in NN Global, Justice Ravi Kumar at para 182 accepts that stamp duty defects are curable. Now, my lord, one other internal piece of evidence to show why the words shall not be acted upon can never be equated with voidness or invalidity. If those words were equated with voidness or invalidity, then there's no question of curing a void act. My lords put it to me. So the fact that you have provisions like 36, 37, 42 itself means shall not be acted upon in 35 can never be extended to an infirmity of invalidity or voidness. That's not what Parliament intended. Now, if my lords kindly go, and it will be very quick with this, my lord, page 19 of these submissions of mine, I've set out reference to a judgment of your lordships on this. Para 44 of my submissions. In Thiruvenkandam Pillai's case, Justice Ravindran's decision, 2008 for SCC 530, and I'll just read para 13, which I've extracted. It's in volume 5A at page 702. But I'll just read para 13 from here. The Stamp Act is a fiscal enactment intended to secure revenue for the state. In the absence of any rule requiring consecutively numbered stamp papers purchased on the same day being used for an instrument which is not intended to be registered, a document cannot be termed as invalid merely because it is written on two stamp papers purchased by the same person on different dates. Then the next sentence, even assuming that use of such stamp papers is an irregularity, the court can only deem the document to be not properly stamped, but cannot only on that ground hold the document to be invalid. Even if an agreement is not executed on record stamp paper, it is admissible in evidence on payment of duty and penalty under section 35 or 37. If an agreement executed, so on. And the last sentence, but admissibility of a document into evidence and proof of genuineness of such document are different issues. Your lordships have held this under the Stamp Act. And para 45, I've set out the instructive judgment of the Calcutta High Court, which Mr. Banerjee also referred to, and Gulzar. And the next para 46, a number of other courts, Bombay, Andhra Pradesh, Calcutta, have held this. It doesn't need to voidness or invalidity. So this is too well settled a proposition. I mean, Lord, just 2 points and I'll be done, Lord. One is, we have viewed this matter from the perspective of section 11(6), court appointment of arbitrators. But there is in existence a huge body of appointment of arbitrators by individuals. There's no dispute to start with. There's also increasingly growing in appointment by arbitral institutions. In fact, the policy of the law is to encourage the interposition of arbitral institutions. There's a proposed amendment which is not yet notified.
All those cases that will go before the arbitrator.
Correct. So I have also said...
Can be in 11(6), why take a different view than what would happen in...
That's right. And I'm obliged. The point I'm making here is your lordship's view on 11(6)(a) must try to harmonize even appointments by institutions.
With how arbitration in other areas, in other methodologies take place.
So, for example, all arbitration institutions have these rules. SIAC, for whom I appear, has rules 28.1 and 28.2, which essentially an objection as to jurisdiction, as to the existence of an agreement, can be initially raised before the full court. The court has the jurisdiction at that stage to knock out a claim if it is prima facie satisfied. Again, the prima facie test. Otherwise, it sends it to the tribunal for a fuller decision. And I may only ask my lords to mark 5 or 6 paragraphs of Justice Roy's decision in NN Global. That is paras 368 to 376, where he surveys the rules of several leading arbitral institutions. All of them have a prima facie test at the first instance. Para 368 at page 462 of volume 5A, up to para 376 at page 466. And he also refers to the Justice Sri Krishna report, which recommended encouragement of institutional arbitration. Because if my lords don't hold the prima facie test in 11(6)(a), then individuals and institutions will be left in a quandary. What do they do? Because the observations in NN Global, albeit in the context of section 11, will apply to them as well. If it is held that an unstamped agreement is void, what do they do? Now, one further problem. Neither individuals nor arbitral institutions are empowered to receive evidence. So they would not be covered by the bar under section 35 of the Stamp Act, because that only applies to persons who are authorized to receive evidence either by consent or by law. Or indeed, they would not have the power of impounding under section 33. So they can't impound. There's no bar under 35, but there's your Lordship's decision in NN Global saying void and non-existent. So they are in a complete quandary as to what to do. Therefore, it is important your Lordships decide this matter holistically, because otherwise a very important segment gets left apart. And there I must say, my learned friends, I've had a cursory look at their submissions. Mr. Shyam Devan, I'll just note it for the transcript in para 4.7 of his submissions, accepts that arbitral institutions have no power to impound, but they might be able to appoint a tribunal because section 35 is not applicable to them. And Mr. Nakul Diwan at para 23 also says arbitral institutions have no power to receive evidence. Equally, Mr. Shyam Devan at para 4.7 agrees that an arbitral tribunal has the right to impound a document under section 33 because it is authorized to receive evidence by consent of the parties, not by law, but by consent of the parties. And therefore, it can impound under 33, which is my submission as well. And one more reason why it should go to a tribunal. And Mr. Nakul Devan in paras 24 and 25 finally comes around to the same view that even under 11, your Lordship should be pleased to refer it to the tribunal. Mr. Shyam Devan raises the point that it may not be convenient for an arbitral tribunal to do this. It doesn't have the infrastructure to impound, send the document to the stamp authorities. But that's an issue of convenience. It's not an issue of law or jurisdiction. But I'll leave it to my learned friends to satisfy my lords why it should not be sent to the tribunal. Now, one point and then I'll draw my conclusions very briefly, Mara. I'll just give the pages because it doesn't arise before my lord, but it puts the matter in perspective. Paras 48 to 58 of my written submissions, pages 21 to 24, deal with this whole issue of who is entitled to impose stamp. Does it come under list 1 and therefore under the Indian Stamp Act?
You need not go into that actually.
They're not required to.
They're not.
But
We saw those entries,
that's
right. You don't have to go into.
I only wanted to say one thing and I'll be done with this. Under the state stamp acts, the residuary articles have stamp duty of 50 rupees and 100 rupees. Now, the process of arbitration ultimately cannot be held up for 50 and 100 rupees, which can easily be cured because all the residuary articles are low figures. NN Global, I'm not going to analyze again. My learned friends have analyzed it. I don't. I mean, not just my conclusions. First is that your lordships should be pleased to adopt a purposive interpretation to uphold the intent to arbitrate. In deference to party autonomy. And I've given some cases where your lordships have done that under the Arbitration Act in Nandan Biometrics, etc. I've mentioned them in my written statement. The second is Section 5 of the Arbitration Act must be given full effect. It's a very wide non-obstante. And the Arbitration Act is a complete code. Your lordships in the Amazon case, I'll again just give the para number, para 43, and the judgment is found in volume 5B at page 623, have held that the new Arbitration Act with the amendments is a complete breakthrough from the old position. Therefore, every provision of that act must be interpreted given the overarching principle of Section 5 and the principle of an implied negative competence. The third, as held in Vidya Drolian, that so long as an arbitration agreement satisfies the requirements of the Arbitration Act ex facie by adopting the prima facie test, there's no question of a court holding up the arbitral process by entering into an examination of whether duty is paid, whether it's understamped, under which article it falls, etc., etc. The fourth, since a tribunal is authorized to receive evidence, Section 33 of the Stamp Act will apply to it squarely. It can impound the document and start the process of stamp collection. There's no reason why a court which is, courts are already clogged with so many matters, why they should be clogged up into this? Fifth, such an interpretation of 11(6)(a) will also harmonize the process between appointments by courts, by individuals, and by arbitral institutions. An arbitral institution certainly will take just a prima facie look before the tribunal is appointed. An individual may not do that. The one who wants to refer to arbitration will refer, the other one will go to section 11. So it's unlikely, but sometimes individuals do, because very often these objections are raised halfway through an arbitration. So it's not unheard of. Then, my lord, 6, the trend is towards encouraging institutional arbitration. The Amazon case has said so, and your lordships are familiar with the Sri Krishna report, which has said so. And therefore, to leave institutions in a quandary and to effectively block the process of institutional appointment by saying go into stamp objections will not subserve this broader public policy objective. And lastly, there is also a trend towards investing arbitral tribunals, a parliamentary trend, towards investing arbitral tribunals with powers of a court. This is the legislative prescription of Parliament. I'll give a few examples. The amendment adding 17(2), which prevents a Section 9 court, which effectively prevents a Section 9 court from giving interim reliefs, because under 17(2), the orders of an arbitral tribunal are given the force of law of orders of the court. And corresponding provision is 9(3). Section 11(6)(a) itself. Section 8 was amended in 2015 to include prima facie, to bring it into line with 45, where under Shinitsu, your lordships had held only a prima facie look to a foreign arbitrations. And even 12. Under Section 12, even impartiality and independence, the first objections must go to the tribunal itself. So the whole trend is empower the tribunals more and more in deference to the principle of competence. And this, in my respectful submission, will subserve the scheme and object of the Act, minimum interference of courts, party autonomy, and one-stop adjudication. And ultimately, in a lighter vein, this might encourage the stream of trade and commerce, and ultimately more stamp duty might result as a result of this, rather than holding it all up for stamp objections to be decided by courts. I'm deeply grateful for the time I've been given.
Who are you appearing for now?
My lords, have been grateful when I was appearing in the Constitution bench for inviting submissions. So 5 to 7 minutes, my lord.
Just one thing.
Yes.
We have to wrap up the proceedings today.
Yes.
It may not be in the interest of anybody that, we leave it on.
I understand.
So what we'll do is, we'll look at the submissions of all the interveners.
Yes.
We would have much liked to hear you all. You put in a lot of industry. Please rest assured we'll read all the submissions of the interveners. If we have something at the end, in response to what Mr. Diwan has argued, and since we have heard Mr. Datar, Mr. Gaurav Banerjee, and Mr. Daras Kambata on this side, in rejoinder, if we have some queries, we'll put them to the intervener. I think that may be better.
2 minutes for one aspect.
We can't give 2 minutes to everybody. Thank you. Yes, Mr. Diwan. We'll try. Do this. Give us your submissions. Yes, Mr. Diwan.
We've narrowed down the controversy, Pranav. Therefore, there's really nothing to be added.
Nothing to repeat. Only then I would just have pointed out the relevant pages of my written submission. That's all.
That we'll read it, don't worry. We'll read it in.
Thank you. Yes, we'll read the submissions. Yes, Mr. Diwan.
I appear for respondents 1, 2, and 4. I appear with Mr. Nikhil Nair. We will divide our submissions. For respondents 1, 2, and 4. I'll request the court master. Yes, sir.
One thing, since we have now renamed the title of this proceeding, the object was also to assuage your concern on behalf of your client that we shouldn't look into the curative aspect, or that you have a preliminary objection to the curative issue. We'll be sending it back to
Yes,
the
but that may
five-judge
not,
bench on
so
the
that
curative.
after hearing us on curative, your lordship may consider whether that's the correct course at all. Because in my respectful submission, that may not be the correct course.
We really want your we want your assistance on the question of law.
I'll do that as much as I can,
Justice,
but we'll do that in 2 stages.
to your client on facts and whether curative should be exercised, we'll leave it to the five-judge bench, and we are not going to come in the way of your.
Yeah, I think, okay, so let me, I've understood what your lordship is indicating. Now let me contest that position and suggest that there is a better way forward.
Yes.
So let me first, so I am going to be making my submission very rapidly because of the constraint of time. I will state my points. I'll request the courtmaster, if you consider it convenient, to hand over, I've given a list of the Constitution of India, the Stamp Act, the Arbitration Act physically, because it may take less time that way, that they may.
We have it with us.
Now, let me just, so I have 2 broad sets of submissions. I am first setting out my points with regard to my first set of submissions. The first submission is that our court, which is the Supreme Court of India, as we understand it, is a means and ends institution. We are very particular about means and ends when it comes to courts below, when it comes to government authorities, when it comes to citizens, and most important, when it comes to ourselves. Because the reputation and credibility of our institution rests on the foundation that we reject expediency. We do not. We have sometimes very honorable objectives, but we do that as the apex court in our country, following, reaching those ends by permissible means. And that is going to be my first point with regard to means and ends, the importance of means and ends, and the importance of the nature of jurisdiction which your lordships is exercising. That's my first point. I now come to my second point. Let me indicate what we are not exercising first. So first and foremost, as your lordship correctly put to me, that look, we have relabeled this, and I'm very grateful for that, because I think it really helps, because the parties know, individuals who read the judgment know. So I think it's very beneficial to have an appropriate caption for the case rather than this. But the caption and altering the caption, does it alter the nature of the jurisdiction which you are exercising? So I ask myself a simple question. What are the jurisdictions which this court indeed does exercise? Are we in the realm of appellate jurisdictions? The answer is no. It's not appellate constitutional. It is not appellate statutory. Is it review jurisdiction? The answer is again no, because review, as I will indicate to your lordships, has been rejected. Are we in a jurisdiction which is original, like 131 or 32? The answer is no. Are we in a jurisdiction of discretionary appeal? The answer is no. Are we in a jurisdiction on an opinion which the President of India seeks by way of a reference? The answer is no. Are we in a transfer jurisdiction? The answer is no. So then what is our jurisdiction? What is this panel constituted exercising? There must be jurisdiction. This is the primary function of every court. You must be satisfied. I'm only saying that. You ought to be, I can't say must be. You ought to be satisfied that the jurisdiction which you are exercising in a panel of seven, I'm sorry.
Where a 5 judges constitution bench has found the view taken by earlier 5 judges bench.
Yes.
To be prima facie not correct.
Correct.
Is a reference to 7 judges not called for?
Yes. So let me answer that straight away. If in an appropriate jurisdiction, I answer that straight away. If in an appropriate jurisdiction, your lordship's exercising a jurisdiction, your lordship finds that a 5-judge bench is not appropriate prima facie or otherwise, by all means you have the power to do so. So I concede and I accept that. But not in the curative jurisdiction. Now I'll come, so let me answer that question straight away first.
The only problem is,
yes,
exactly.
I'm so sorry.
That
No, there are fundamental issues. I'm sorry.
That doesn't really survive, subject to what you say.
Yes, of course.
Because even when you were arguing earlier,
you
said this is not a case for curative.
Sorry?
This is not a case for curative.
That's my submission. I mean, it's ultimately for the court to hold.
Case for curative, you may be right, you may not be. We can't
Correct.
But you said, look, don't in a curative petition appreciate these submissions.
I'm sorry?
Don't appreciate these submissions or debate these submissions in a curative petition. Correct?
Yes.
That was your submission.
That's what means and ends is about. You must be exercising a legitimate jurisdiction. Legitimate meaning not that it's illegitimate to exercise. It is curative. The point I'm making is your lordships are sitting exercising a seven-judge bench, and I have no problem with 7-judge bench at all or 9-judge or whatever. But the issue still is the core nature of your jurisdiction today is curative and nothing else, which takes us to, I'm sorry.
When a position of law,
yes,
we are a constitutional court.
Yes, of course.
When a position of law is liable to cause grave public injury.
Yes.
Public uncertainty.
Correct.
And grave unsettling in the world of business and investment.
Yes. Yes.
Surely, the point of time at which the controversy should be resolved should not be left to the vagaries of future litigation. Is the duty of the court to seize upon the opportunity?
Yes. Answer is yes.
And at the end of it all, we may still dismiss the curative petition against you.
So the answer is yes.
Because we are equally conscious of the need to do justice to the facts of that case. So the curative petition can be still dismissed after the decision of this court is rendered.
So let me answer.
Setting the law correct.
So Manoj, let me just answer that. First and foremost, if this court finds in an appropriate jurisdiction and in an appropriate cause that there is some decision which requires reconsideration, which is absolutely your function, and I would take it higher, even perhaps your duty to correct the position in law, it ought to be, as we understand it, in an appropriate proceeding. So now let me just answer the questions which your lordships have put to me. There are two ladders here. The first ladder is a curative ladder. As we understand it, the ladder narrows in the sense, in our understanding, review jurisdiction is narrower than the main appeal, and curative, in our understanding, is narrower still than review jurisdiction. If that be so, then this is a very narrow issue. So I come to my second point. Curative, as we understand it, as understood by this court, and I'll place those decisions, is with regard to doing justice for a particular individual cause. When we go to Hurrah, your lordships will see, it's a case in that case to do complete justice, that individual case. The curative jurisdiction, there may be several situations where you have incorrect law or something which is staring in the face. We don't accept that we'll come to, of course. But it's very important to follow the means and ends test. And I'll tell your lordships why. NN Global ought to. It may come up on an appropriate separate ladder. Curative is a 3-rung ladder, as we understand it. The first rung is the disposal of the case itself. The second rung is there must be a disposal as far as the review is concerned. And the third rung is thereafter a curative petition with all the safeguards that the court has laid down. That's the 3-rung process of reaching this court in curative jurisdiction. Now is a submission. You cannot bypass these 3 rungs because, and let us remember, the curative jurisdiction, although now in our Supreme Court rules, your lordships have continuously exercised, it's a self-created jurisdiction. It's a jurisdiction because the demands of justice sometimes stare an apex institution like your lordships in the face. And oh my, how have we allowed this to pass? And in a situation such as that, for that individual case, yes, you have created this very, very narrow jurisdiction to yourselves, required an appropriate certification, restricted it to grounds, and said that and only in those cases, even though you don't find any provision in a statute or the constitution, we will, because it's our paramount duty, and you trace it to 142 as we understand. So 142 generally may be wider. 142 as a source of power for creating curative and for exercising curative as we understand it is limited to a cause, to a particular individual cause. That cause may, in certain situations, affect a large number of people. I accept that. But here, what has happened is, now, Manoj, I'm just answering the question. Sorry.
There can be a legal cause and there can be a factual cause.
So, yes, let me answer that.
Factual cause is being segregated, as the Chief Justice put to you.
Yes.
To keep the curative aspect, in a sense, out of it.
Yeah.
But we do believe, and seven of us do believe, that there is an unsettled legal position about the facts, which has own ramification, and the Chief Justice put it, it becomes the court's duty to, in its endeavor.
So I quickly end that. I quickly answer that. My answer is yes, it is the duty of the court. But if we are right, on means and ends, then it's a duty of the court when and where. So I'll come to that straight away. It is the duty of the court when NN Global in an appropriate proceeding is doubted, the 5-judge bench. It goes by way of review and then it is before curative. That is a separate ladder. And it's important to maintain these ladders. It is not permissible, according to us. I mean, it's not permissible, it is not desirable, and according to our understanding of the law as laid down in the judgment so far, it is, your lordships have restricted curative continuous. I mean, restricted in the sense when the justice of the case demands, so I'm sorry.
Difference of perception on this issue.
Yeah.
The issue is that someday your submissions
Yeah.
are bound to be affected or colored by the fact.
No, but
that why my curative petition?
Sorry?
Why my curative petition? Why are you doing this in my curative petition? That's the bottom line of what you're saying.
No, that's not. There are two elements here. The first element, your lordship is right, that it is in my, because I'm briefed in this case, so I have to say that please, I mean, don't upset my apple cart. My agreement, by the way, I mean, this is quite amusing. My arbitration agreement is of, your lordship will not dare suggest the year. It's of 1997. My arbitration agreement is of 1997, and I was telling myself, 26 years down the line, we are thinking of appointing an arbitrator, and I mean, what a joke. But for the fact that it's a serious question of law, which your lordships are considering. Sorry.
I told my Chief Justice on the lighter side in Chennai, I have had to refer an arbitration in the year 2015, an application filed in 1999. It was a live dispute. It was accepted as a live dispute and I had to refer. The unfortunate part was that the only unfortunate part was the application was not taken up. So therefore, we are not getting into the facts of it. Therefore, somehow I feel you are more troubled by the fact that why are your clients being troubled in a curative jurisdiction?
So I will
therefore at the threshold itself, looking to your submissions on the earlier date.
Yes.
The file referred to the same.
Yes.
We thought we had taken care of this issue. By not looking into the curative issue at all. And that's something, Mr. Datar. So the curative will be.
But the question I asked then, I mean, of course, a Chief Justice can constitute a panel of 7. But then what's the jurisdiction this court is exercising today?
Determining the legality of the view taken by
That's an opinion or a reference which the President of India has sought. Which is this jurisdiction? It is only curative. Anyway, let me just, sorry.
Mr. Diwan, your basic objection seems to be that while examining a curative petition, the legal ratio raised in the decided in judgment should not be relooked at by a larger bench.
I'm sorry, Manoj, read last.
While examining a curative petition or while deciding a curative petition, the legal ratio raised down by a 5-judges bench or any smaller bench should not be looked into. That's a larger perspective, but in a given case, where we find that the business ramification or other issues have arisen, which have raised some doubts and issues. Why not examine it? We are not saying that curative petition is going to be examined on facts itself separately. So if there is some doubt or debate on the legal principles laid down, legal ratios laid down, which have wide ramifications in fact, why can't we go into that?
No,
why should we?
I'll tell you, Lord.
It's really speaking, here the means are right, because if there is some issue which has arisen, which has led to a lot of disturbance, then it's the right means to also check it. It's not something that we are usurping a jurisdiction which doesn't rest with us. We are all adjudicators, we have to adjudicate, we keep on re-examining ourselves, correcting ourselves. That's our jurisdiction.
So now I'll follow. So let me just be very brief on this point and let me give you the page numbers and the dates. May I just indicate it? I'm not, please don't misunderstand me. I'm not saying that a 7-judge bench can't overrule a 5-judge bench. That's not my case. My submission is, of course you can. But if we are a means and ends institution, then it ought to be in an appropriate packaged case and proceeding. And this may not be an appropriate proceeding for 2 reasons. Now let me just, for several reasons, let me just indicate those. And since your lordship, I'll state the points. If your lordship wants me to go to it, I will go to it. But I mean, we have the pages here. So the first point is that the ground given, please just note this. The first point is that the ground given insofar as the curative petition as contained in the certificate is that there is a reference which has been made to a larger bench in NN Global. So this is the primary ground. This, in my respectful submission, cannot be a ground for the purposes of issuing a certificate. Your lordships have deprecated certificates of this type, and I believe it ought to be deprecated here merely because there's a reference which has been made to a 3-judge bench. So that's absolutely no ground. Now, if there is no ground which is made, which is sustainable insofar as a curative petition is concerned, the question of igniting the curative jurisdiction does not arise. So this is one primary set of submissions that I have. If your lordship likes, I can give you sorry.
Security with it. That's the. When 5 judges may be sitting in curative jurisdiction dealt with it. He is not denuded of the power to constitute a larger bench to examine the question.
I agree that. I agree with you.
That's all we are doing.
So, Manoj, may I just say this?
Even there, we did not let them argue even further. Is something which needs to be looked into or relegated to arbitrator. There also we have not permitted them to expand the contour. We have some of them.
So,
have argued
anyway, your lordships have followed my point now. So I'll just give you the points. So the first point is
we are
that,
giving you we are leaving it to you to fight another day on the curative petition. We are not dealing with that aspect. We are today not, please take it.
Well, I think, frankly, I mean, I'm just making a suggestion. If you do find in my favor that the essential elements for a curative jurisdiction are not made out, then my respectful submission would be the appropriate course is to decline to exercise this jurisdiction, because you are exercising no jurisdiction other than curative today. When you pass the order suggesting that you are clarifying it, etc. There is, sorry, that's my understanding of the law. But I mean, if your lordship finds that there is some other jurisdiction which is also being exercised over here, I don't find any. Sorry.
We've said repeatedly that so far as the curative matter is concerned, it will be heard by a 5-judge bench. Whether they agree, disagree, dismiss the petition, the facts of the case is a separate matter. But on a general principle of law, 7 judges of this court felt, led by the Chief Justice, who exercised his discretion. We have segregated it yesterday. We have said we are only.
So, let me just proceed now. I've followed the point. So, let me just state my points and then your lordship will consider them appropriately. So, my first submission is that by relabeling it as in re, etc., it doesn't alter the nature of the jurisdiction or exercising. That's my understanding of the law. The nature of the jurisdiction remains the same. That's point one. Point number two, if you are choosing to exercise curative jurisdiction, which of course you may, there are well-settled parameters, and I'm just indicating those parameters. I'm just mentioning them because they're in our submission. I'll list them. Sorry.
Mr. Davin, problem is, Mr. Diwan, that we are not looking into it. So you're arguing something which we are not looking.
No, but if it's curative and then your lordship say that it is.
See, it's a catch-22 situation.
It is a catch-22.
You can't do it in a curative because there are restricted parameters. Okay.
All right, let's keep that aside. Let's keep that argument.
We are not doing it. We are only looking to one proposition of law. He holds this curative.
All right.
Whether in case of a 11-6 jurisdiction,
all right,
stamping is something to look about.
Okay, so now let's drop this. Now, I'll next 3 sentences, I'll try and not use the word curative. Supposing in a theoretical situation, a very, very wrong judgment comes out by this court, and it is brought to the attention of the Chief Justice of India or senior judges, etc. That look, this looks, extremely wrong and very perilous. The question I ask myself is that can the court thereafter constitute a bench of a larger panel, put a label in re, and then decide the issue to overrule that? I don't believe that is acceptable. That's my understanding of the law. I believe that can certainly be done in an appropriate case. An appropriate case comes up. That's what means and ends is about. But not, sorry, that's our understanding.
The impact of a wrong precedent is so severe.
Yeah.
And as our history has shown, by the time you actually get a case, an appropriate case, what you have to ensure is that you do not confine your arguments only to one or two.
Yeah.
Therefore, we have invited a broad diversity of views.
Correct.
On this side,
Yes,
on this side, we have, that's the idea.
So let me, Manoj, move on. So Manoj, I said I won't use that expression. My understanding of the law is merely because there is a wrong judgment. Our understanding of this institution and its working, our understanding of this institution and working is that we improve, we self-correct, but there are methods and ways of doing it. And I am suggesting to your lordships that this may not be the appropriate way of doing it. Your lordship's answer is we are keeping your objection alive for another day. Fair enough. But then what's the nature of the jurisdiction in arriving at this conclusion of whether X is right or whether wrong? It is the jurisdiction which I said I won't speak about. So that's the very jurisdiction. Now, if that's the jurisdiction, then please follow the parameters. Now I move on. You may just note that in my case, there is a 337 days delay in file. So I've said the certificate isn't there in terms of Rupa Hurra. I have respectfully submitted that the agreement itself, of which the arbitration clause of 1997, so please keep that in mind. There is a 337 days delay and there is a 505 days delay after the dismissal of the review, a 505 day. And your lordships have said that as far as a curative petition is concerned, it cannot be filed as and when a party considers it. So, sorry. So this really ought to be closed. I'm sorry.
I'm only saying you will argue this somewhere else. That's all I'm again. So we understood your point. Why take it up here?
That's really up to the court to hold as to whether there is a means and ends. There is something in the means and ends submission.
We have understood your means and this thing. Point.
Yeah.
You feel no, there is a procedure which must be followed. We felt that it is a very large ramification. We should not wait for a particular case to arise, then to be referred to 3 judges, then to be referred to 5 judges. That is why Chief Justice placed it. We have heard not the parties alone, we have heard everybody. So this is not something which is a list being decided and to see the parties in that sense. And therefore, at the threshold, we kept it. So to the extent you feel don't do it in this manner, we have understood it.
Yes. Ought not, well, I said, I'm not saying don't do it. I'm saying we ought not to do it. I mean, who am I to say don't do it?
On the lighter side, we've done it.
Means the same thing.
Perhaps ought not to do it. That's how I'll put it.
We've done it now because in this manner, we feel we have to
Very
close.
well. Anyway, your lordships have now followed the point. So I now move on to my next point. Now, your lordships have the Arbitration Act with you, or should we go to the sections which are mentioned here? Okay, let me just indicate to your lordship. I'll take you to the act as it appears from the record. I've now kept that whole issue aside. Now, my lord, sorry.
I understand you correctly that as a proposition of law, you want to canvass that the issue of a stamping of an agreement should be looked at in 11.6 itself. Is that the proposition you are advancing?
Yes.
So it has,
Yes. So, Manoj, let me simplify.
you are in different jurisdiction.
Okay. So let me now, Manoj, let me simplify. Let me give you my understanding of the law. If we take up the Arbitration Act or whatever electronic copy your lordships are referring to, there are 3 situations which arise. So I'll give you my conclusion on all 3. The first situation which arises is the law as it stands today. If we pick up the Arbitration Act, I'm only on 11.4 at the moment. You could have a Supreme Court / High Court appointment, depending on international or domestic. That is situation 1. Situation 2, as 11.4 stands today, it could be through an institution which is designated or appointed for the purposes. That's the second situation. So 11.4 as it is applicable post 2015 Act today. The third aspect, the third dimension is what Mr. Khambata mentioned briefly, which is that, look, we now have a 2019 statute which has not been brought into force, which sends the matter, Justice Khanna also mentioned it, which sends the matter into the realm of an institution, correct? So first, let me clear my position. If it is to go, 11.4 is to go directly to an institution, in my understanding of the law, there is no impediment in terms of stamp duty. So the moment the 29, and that's in fact one of the reasons why I'm going to request the court, please do not exercise such jurisdiction as you are choosing to exercise. because there is already a statute. The statute refers parties straight off to the 2019, under the 2019 amendment to an institution. It does not require any interference or any intervention by a court or any application of mind on the part of the court. That body will not be a body which is entitled either by the consent of the parties or under law to receive evidence, and therefore the stamp duty question will completely pale into insignificance. So that's one situation, so it will not apply. So this problem won't arise. All that is needed is the 2019 Act is brought into force, the relevant provisions, and the problem disappears. That's one. So this has, of course, multiple dimensions to it, including whether your lordship should even at all exercise jurisdiction. You'll keep that at the back of your mind. Now we come to the second situation. The second situation is, your lordship may just go to section 11 for a moment. Just have a look at section 11. As it stands today, you will find it at page 1210 of volume 4A. Your lordships have it? Yeah. So, fellows, I'm now reading 11, appointment of arbitrators. We are on page 1210. Appointment of arbitrators. A person of any nationality may be an arbitrator unless otherwise agreed to by the parties. Now, subsection 4. If the appointment procedure in subsection 3 applies and a party fails to appoint an arbitrator within 30 days from receipt of the request to do so from the other party, or the two appointed arbitrators fail to agree on a third arbitrator within 30 days from the date of appointment, the appointment shall be made upon request of a party by the Supreme Court, or as the case may be, the High Court, or any person or institution designated by such court. So again, I'm just indicating to the court our position. If under the law, now 2019 Act, I've said, that is not brought into force. Even under the law as it stands today, there are two situations. One, which is the one which commonly prevails, which is that the High Courts and the Supreme Court continue to appoint. But there is also an expression, or any person or institution designated by such court. Now, when this went before the High Power Committee, or what Mr. Kambata referred to as the Sri Krishna Committee, they looked at the provision as amended by the 2015 Act, and they, following on the earlier Law Commission report, were both of the view that even this provision as it stands today does require the court to send it to. So there will be some application of mind on the court. So therefore, they have introduced, they've recommended the suggestion, they've recommended in terms of what is to happen moving forward. And the recommendation is, once the 2019 Act comes into place, there won't be any reference to that as well. So I thought I should place this before you.
Even if one looks at the provision as it applies today, in fact, none of the High Courts or the Supreme Court has done it. But if we had passed, the High Court or the Supreme Court had passed a resolution and designated authority or an institution, all 11 applications would go to that institution. Under the law existing as of now,
yes.
Once the High Court or the Supreme Court authorizes the institution, then that institution will appoint an arbitrator in 11-4. All of them.
No,
We have not done it. That's a
may I
different
just
matter.
respond to
That's
that?
a different matter.
No, but may I just, Miller, that is a possible, that's a possible view for your lordships to take. So then the situation is that you have a situation where moving forward post 2019 Act, there'll be no question of such a problem at all. And secondly, if the prima facie view which was expressed by your lordship just now a moment ago is that if there is a designation by a High Court, then that's another way in which the entire problem may go. But I thought I should just mention to you that the Sri Krishna Committee, when it made its recommendations, read this very provision differently, leaning on the earlier Law Commission report, which also took the view that even as the post-2015 Amendment Act, there is still an aspect which is left for the court. But that's really, that's controlling. Your lordships are left to decide that aspect.
Then as it's, law stands today.
So look at it only as it stands.
What may happen tomorrow, one doesn't
Yes,
know.
but I
It
thought
comes
I
into being, they.
You're right.
They seem to be having another law, what form it comes.
Correct.
Today conjecture only.
Correct. So just, sorry. So focusing on the law as it stands today, we have two situations, not the third situation as I mentioned, either High Court or Supreme Court or High Court, and or institution designated by the Supreme Court or High Court. My personal view is that if it becomes, once there is a designation and if there is the rules, etc., provide that you go directly to that particular institution, then that institution doesn't have the power to receive evidence, or it's not by consent of the parties that that institution has been given authority to use evidence, etc. So in a situation such as that, again, the problem will disappear.
But Mr. Kambata pointed out, that was your para 4.7 of your.
Yeah, so so we're quite right. So we accept that position. So the problem is actually being contemplated. I mean, there is a solution within which is contemplated.
When the High Court or the Supreme Court, as the case may be, are exercising their power under 11.
Yes, so that's the one which we are just now looking at, correct? So now have a look at Section 7, please. So there are two, three elements of the Arbitration Act. Then I'll go to the stamp act. Just as I might just mention, I'm just digressing from here. In my case, and your lordships, I had mentioned it on the last occasion that the parties I'm representing, one person is 90, the other person is 89, and it's rather difficult to explain to them why we're here. But I should mention, there is a decree.
Still, on a lighter vein, there may be still a case for the award of costs to your client payable by the petitioners.
Yeah. So, I just want to mention, there is a decree in my case. So I had filed a suit in 2010 in my case. I had filed a suit in 2010. The suit got decreed after a written statement was filed. So they never objected under Section 8. My suit got decreed. And therefore, I don't know whether Justice Gawai and Justice Suryakant recall, because it's a long time ago that they passed that order. So apart from the stamp duty case and stamp duty issue in my case, they examined the case on merits. And they say now on merits also, we don't think there is any question of arbitration. So the question I ask myself, where is the question of overturning that decision in that curative jurisdiction at all, when the court has decided on two footings, law as well as this. But anyway, now let me come back here.
The court.
Yeah.
For arriving at a conclusion, whether under Section 11.6, stamping is something to be done.
No, we'll get into that. Right.
So we will actually not go beyond it. Whether they have argued, you argue, it will not go beyond that.
All right. So now, I just want to emphasize a few elements as far as Section 11, Section 7 is concerned. Just 2-3 parts, and then I'll take you to 16, and I'll read 5 as well at this stage. So just see 7 because there's something which we wish to emphasize. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. 2, an arbitration agreement may be in the form of an arbitration clause in any contract or in the form of a separate agreement. And 3, the arbitration agreement shall be in writing. Now, I will take you to the definition of instrument, which I think your lordships have realized that we are relying on the Indian Stamp Act, not because it may apply to individual cases, but it's the same thing which is borrowed across the state. Paramateria, we've emailed a set of comparative provisions. It's all in paramateria. So the point here I'm making is it has to be in writing. I don't think there is any dispute with regard to that. It's required by law to be in writing. That's number 1. And in our understanding of the law, if it is required to be in writing, when I take your lordships to the provisions of the Stamp Act, you will find that it answers the description of an instrument. So that's all at this stage. Now, since we are on this page, which I believe is page 1207 of volume 4A, please just have a look at Section 5 as well, since we are on this. Yes, sorry.
4 also. Why don't you have a look at subsection 4 also?
Yes, of course, I'll read it. 4.
Just 1 minute.
Yes, of course.
Just 1 minute.
Yeah.
If we turn to clause C, subsection 4.
Yes.
To section 7.
Yes.
Exchange of statements of claim and defense in which existence of an agreement is alleged by one party and not denied by the other.
Yeah.
Let's suppose
there's
a parent arbitration, underlying contract, under stamp, whatever it is.
Yeah.
But a statement of claim is exchanged and defense is also exchanged. Both the parties agree to an arbitration agreement. You need not therefore rely upon the parent clause.
It may
the
be.
cause in the.
Of course,
parent.
that won't be at a
So,
section
and
11
the
stage,
fact-
may
the
not be at a
fact-
section 11 stage.
Just one.
Yeah.
The fact that the parent agreement is understamped or non-stamped is immaterial then.
Sorry?
In that case, for going into the question of existence of an arbitration.
You're right. There's a deeming fiction here. So let me, now I'll read the whole of 4. I'm grateful. This 4 is very important. So please have a look at it. And I'm on section 7, subsection 4. An arbitration agreement is in writing if it is contained in a document signed by the parties, B, so this, I believe, would answer the description of an instrument straight away.
Correct. You're right.
B, an exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement. Or C, an exchange of statement of claim and defense, in which the existence of the agreement is alleged by one party and not denied by the other. So, Manoj, just coming straight away to clause 3.
Exchange of emails.
Sorry?
Exchange of emails may also constitute an arbitration agreement.
It may. So, okay, so now I'm just getting a little ahead of the script, but just let me tell you what, where we are, the suggestion which we're going to make. There is because I think your Lordship is also looking at it from a practical point of view. I mean, what happens in a situation? So let me just depart from this section and just provide, supply what we consider is an appropriate cause. Before our understanding of the scheme under the Stamp Act is on execution or before execution, stamp duty is payable. That's first point. However, apart from that situation, supposing the contract is being worked, there are no disputes. There are no disputes at all between the parties. The contract is being worked. A party can all, and the parties did not pay the stamp duty at the time of execution or before execution as required by law. They can always go under section 31 is our understanding and have it adjudicated by the collector. So that's the second clear method by which you can solve that problem before disputes, etc. arise. The third issue is, before you issue a notice, because presumably of arbitration, I mean, the sorts of cases my learned friends are on, Singapore Arbitration Center, Hyderabad International Arbitration, those kind of cases. Ordinarily, you'd go to a lawyer. You would ordinarily require a notice to be sent. You are preparing a section 11. Ordinarily, there will be some individual cases who prefer to do it all by themselves. That is the stage at which you could conveniently, if you find that the agreement, whether the composite agreement or the arbitration separate agreement hasn't been stamped, get it adjudicated. The moment it is before adjudication, no court or either the High Court or the Supreme Court under exercising powers under Section 11 is going to stop or block, because your point will be, I am a compliant citizen. Maybe at the stage of Section 11, before issuing the notice and before approaching the court, I have approached the appropriate revenue authority. This is what I think is the amount. I have gone there. Please appoint an arbitrator. And the court would not, in a situation such as that, say, oh, I can't look at the document, it can't be seen. It is pending adjudication. The court can also, and I'm going to show you Lordship, because after NN Global, 5 judges, both the Bombay High Court as well as and earlier, the Delhi High Court have rendered a judgment which have given a scheme following NN Global, which is time-bound. But I am just now not without any intervention of the court. What is the correct procedure to be followed, which is fair, equitable, and doesn't do injustice either to the parties or the statute? Because what the submission over here was that Section 5 is wide enough. I'm going to take you to Section 5. Is wide enough to override everything. I don't even think that's constitutionally permissible, but I'll come to that separately. So the answer to the question is what happens at a practical level. This is what happens. First stage, before you execute or at the time of execution. Second point, shortly before you move a court or before you issue a notice of arbitration, at that stage you can go and approach. And the third point, which your Lordships can clarify very simply, is that in a situation such as this, where a party has indeed approached the collector, there is no question of holding up Section 11 at all, because the party is complying with the mandate of the Stamp Act, and therefore please proceed ahead and go ahead and appoint the arbitrator if you are satisfied that that's a much better, balanced, revenue compliant, statute compliant, and consistent with our court's line of reasoning over a decade, which would meet the ends of justice. So to answer your Lordship's question, as far as 4B, You're right. An exchange of letters, telex, telegrams, and other means of telecommunication, including communication, which provide a record of the agreement. So you could have two types of agreement. You could have either just the arbitration agreement through this exchange, or you could have what I will call the larger agreement, of which the arbitration agreement is but a clause. In both situations, before you initiate the process and approach a court, if you find that this requires stamping, you take advice, you submit it to adjudication, and that's the end of it. You've cleared the whole hurdle. There's nothing further which is required to be done at all. We'll come to that. Sorry, I'm sorry. Yes, certainly.
Somebody feels the
agreement
is properly stamped. Let us say. Another person says the agreement is deficiently stamped.
Yeah. The
moment this is done, you are wanting them to move to the collector's stamps to get this adjudicated first, whether it's deficiently stamped or not. If they move 11.6, the concerned arbitrator will decide whether it is deficiently stamped, it is properly stamped.
Yeah, so I'll come to that. If it's permissible in law, of course, that's one.
So
Well, you see,
why should the whole issue is in 11.6, what can be done by the arbitrator? Detain the court in 11.6. This is the only issue which is there.
I agree with you, but Manoj, there is, I mean, your lordships have seen, there is a long line of judgments, and there is good, I will, of course, try and develop and I'll answer. I'm alive to that issue which is troubling. In terms of, your lordship wants our assistance on what is the appropriate statutory design today, not what is desirable. So there may be some situations which are desirable. Why not go here and why not go there? But does it lend itself to a possible interpretation of the type which your lordship is suggesting? That's really the question. Or do we go by the rigor of what we believe is the correct position? So your lordships have now seen 7. Now, since your lordship is just on that very page, just have a look at section 5 now. Please just see this and I'll just state the point quickly. Extent of judicial intervention. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Now, my lords, I would respectfully submit that the purpose and object of this section, as consistently understood, is that you don't allow suits to be filed to block arbitrations, applications which are not contemplated under the Arbitration Act, some other type of action which would delay or prevent or stop the process of arbitration from moving forward. That is the purpose of Section 5. The purpose of Section 5, as we understand it, is not to override a statute such as, and a mandate of a statute, if we are correct, under, say, the Stamp Act. Let me read it again. Notwithstanding anything contained in any other law for the time being in force in matters governed, no judicial authority shall intervene. What is the meaning of judicial authority intervene? You are invited through some sort of an interlocutory application, through some sort of a suit, through some sort of other action to block an arbitration proceeding. That is the intention of this particular statute. Now, I just raise a second issue. Your lordships correctly flagged the question regarding, and Mr. Kambata was also correct, with regard to the, your lordship, just give me a moment. Yes, with regard to the legislative competence of those various entries. So your lordship recalls that there is 91, item 91 of 7th schedule, first list, 63 of second schedule, 7th schedule, I'm sorry, list 2. And arbitration comes in the concurrent list. Now, the question which I am posing, because I believe that the interpretation which is being suggested by them, that please use Section 5 to trump, so to speak, all these stamp acts, is constitutionally infirm. And I'll just state my point why. Stamp duty, as we have just indicated, falls within the respective legislative realms for the purposes of taxation or finance or raising revenue. We don't believe that in exercise of powers to frame a arbitration law, Parliament can trench upon an act or a power which is left with the state legislatures to impose or an exaction in the form of stamp duty. So section 5, it would be very dangerous. I mean, this is a submission. It would be incorrect. Let me not say dangerous.
For arbitration, that is.
Arbitration is, I think, 13(3), Roman, 7th schedule, list 3. 13.
And arbitration. Yeah.
Your lordships have that? Civil procedure, including the manner included in the Code of Civil Procedure at the commencement of the Constitution, limitation and arbitration. So, this is
the purpose of the Arbitration Act is not to prevent the collection of revenue. The question is, what is the stage at which that has to be exercised?
I agree with
The
that.
forum
I'm just
which will
saying
determine, see, ultimately it's the forum which will determine. Nobody is saying states' revenue is to be jeopardized.
No, that of course. That we'll have to get into the Stamp Act.
In balancing it, you say, okay, let the whole matter proceed to the chosen judge, which is the arbitrator.
Right.
Instead of normally a court would adjudicate it. Now here.
So whether that can be done, not whether it's desirable, but whether under the statute as it remains,
is whether if it is sent to the forum, the forum, which is the chosen forum.
Yeah.
That forum will determine whether it's deficiently stamped, unstamped, does it require stamping, etc. Why under 11.6 detain it? Contrary to the whole concept that you choose a judge in arbitration, and therefore the chosen judge will decide which way to go. That's all.
I don't think there's any problem on that at all.
That's only thing I say.
The question, at least the way I would look at it is, as to whether, let's see the two issues over here.
Why I put it to you was, they've also.
No, first of all, I agree with what your lordship is saying. Namely, I am not disputing that the arbitrator can't do it. I am not for a moment. The question is at an anterior stage. Sorry.
Get to that part. They've argued many issues.
Yeah.
At some stage, we have been trying to say that, look, what we are examining is a very limited contour.
Right.
Given there is 11.6, there is a power.
Okay.
That there are some cases where need to be shut out under 11.7.
Right.
As the Chief Justice put it. But stamping is an issue being curable, and it's a defect, but a curable defect. Revenue related.
Yeah.
Let the arbitrator determine.
Right. So,
what you're wanting to say.
So correct. So I'll just respond to that straight away. First of all, sorry.
Sorry, interrupting.
No.
Because once, are you also accepting it's the separation between the severability of the arbitration agreement with?
Yes.
Let's assume the contract is found to be void. Let's assume the contract.
Yeah.
Section 65 of
the general contract.
General, for some reason.
Yes.
Section 65 of the Contract Act applies.
Right.
Then also you have to compensate.
Yeah.
If the arbitration agreement is valid,
right,
the arbitrator will then apply Section 65.
Right.
Of the Contract Act.
Yes, of course. But provided it is appropriate.
Let's assume so.
Right.
Suppose for non-stamping.
No, I accept that. Your lordship is right. I agree. It can be done. But
that answers the question. Why should we stop the arbitration?
Should I just, well, first of all, I accept the position. I don't think anybody is contesting it, that as far as the arbitral tribunal is concerned, the arbitral tribunal has jurisdiction. The issue is, when we are going through a Section 11 route, and the expression which is used by counsel on the other side is, that arbitration agreement, according to us, has to be seen before you appoint under Section 11. Has to be seen. Now, that examination of the arbitration agreement, what is the mandate under the Stamp Act? Does it get in any manner diluted by, when a court looks at it, does it in any manner get diluted by the provisions of the Arbitration Act? And is it a situation where only one forum is to look at it? Or is it a situation where, potentially at least, you can have or is requirement, the requirement of law is that the court, if it comes up before the court for the first instance, the court ought to look at it. That's the I understand the point.
You see, being a curable problem, a revenue generating issue, that it has to be looked into, certainly nobody says can't be looked into. Why should under 11.6, which is a very, very minimal intervention, deal with this issue? Why should it not go to an arbitrator? Because
all right, but so I follow. But the question is, what is the law as it stands today? I think your lordship put your
today's law.
Today's law. Now just have a look at 16. Please just look at 16. Please look at Section 16, which in terms of the PDF, I mean rather the volumes, you'll find them at 14 capital A, volume 14, 4A, I'm sorry, 4A 1214. 1214. Now just look at competence of arbitral tribunal to rule on its jurisdiction. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement. And for that purpose, an arbitration clause which forms part of the contract shall be treated as an agreement independent of the other terms of the contract. So this is being used. So as far as severability is concerned, there's no doubt that the arbitration. However, there is a limited fiction. I'm borrowing your lordship's words. The fiction is for the purposes of section 16 determination. It's not as if that for all intents and purposes, this becomes a standout clause, a separate agreement, and if that agreement is stamped, it is to be regarded separately. No, it is only for that, please see the expression, existence or validity of arbitration agreement, and for that purpose, the arbitration clause which forms part of the contract shall be treated as an agreement independent of the other terms of the contract. So I would respectfully submit this is a very limited fiction which is coming in. The language is very, very clear.
11.6 uses the word examine.
11.6, yes.
16
Let us see 11.6.
Ruling.
Yes.
There's a very distinct connotation in law between an examination and a ruling. A ruling implies a binding determination. Examination means a scrutiny. So the power of the court, the first look.
Yes, the first look. Yes,
very beautifully put it in para 126. Is the first look is for examination, a first level scrutiny. It's not rendering a binding determination, because when the legislature has used two distinct words, examination in 11.6 and ruling in 16, ruling means actually a binding or a conclusive finding.
So let's just have a look at section 11.6a. Now we are going back. I've made my point. It's for a very limited purpose that section 16 treats it. So your lordship is going back to to section 11, which is on page 1210. Please have a look at 6a. The Supreme Court, or as the case may be, High Court, while considering any application under subsection 4 or subsection 5 or subsection 6, shall, notwithstanding any judgment, decree or order of any court, confine to the examination of the existence of an arbitration agreement.
Very limited scope.
Very limited.
We'll come back.
My lord, one thing which will cut short judicial time, section 33(2)(b, Stamp Act itself provides for delegation of those duties to an officer. An arbitrator would include that, my lord. That provision may cut short a lot of conflict between the two acts.
Section 35 will have to be.
Yes,
Roughly how long would you take? Because there's another matter. That's why I'm not otherwise to stop you in the ranks or anything. So that we'll adjust that other matter.
I'll try and wrap
There's
up.
a reference to a three-judge
half an hour, I'll take half, but Mr. Nair is going to
take half an hour, 15, 20 minutes, half an hour, whatever I can get.
Because we restricted it. We restricted, and you are for an intervener.
Because that's correct. In fact, like Mr. Kambata. No, look, Mr. Kambata was appearing for the CIR, appearing for the Hyderabad Center. Look, my proposition is actually going to be based on severability. Which, Manoj, in fact, I have a different position compared to what Mr. Kambata has taken, because in my respectful submission, you cannot expand severability.
But at the end of the day, I still come back.
There's a three-judge bench between me, Justice Pardiwala, and Justice Manoj Mishra. It's a difference of two judges on that medical termination of pregnancy. We'll take that up at sharp 2 o'clock, and we'll come back in a combination of 7 the moment that gets so. It should
all right, very good. Well,